Hello students and welcome to the lecture. So students, as we know that we are covering the parliament, right? And these are the topics that we have scheduled for the discussion under this particular series. So there are total 18 topics, and if we talk about the topics that we have finished so far, so we have done with the introduction part, we have done with the organization of parliament, we have done with the composition of the two houses, we have done with the system of elections to the Lok Sabha, we have done with the duration of two houses, we have done with the membership of parliament, we have done with the presiding officers of parliament, we have done with the leaders in parliament, we have done with the sessions of parliament, we have done with the devices of parliamentary proceedings, we have done with the laicity procedure in parliament, we have done with the joint sitting of two houses, we have done with the budget in parliament, we have done with the multifunction role of parliament, we have done with the ineffectiveness of parliamentary control, we have done with the position of Rajya Sabha. So these are those topics that we have covered so far. Got it? If we talk about the topic on which we have been discussing on, so that is the parliamentary privileges. Okay? And if we talk about the topic that we are left with, then it is the sovereignty of the parliament. Okay? So you can say that this is the picture that we have created so far altogether. So basically in this lecture, we will start from where we had left in the previous one. Okay? Before this, let me tell you one thing. When we talk about the parliamentary privileges, as we have discussed, so basically these are of two types, the collective privileges and the individual privileges. The collective privileges are the privileges which are granted to the house as a whole. Okay? While the individual privileges are those privileges which are granted to the house members. Okay? So let's start from where we had left in the previous lecture. Okay? So from here we have to start this lecture. So we know that the parliament provides the privileges to its members in a two form, whether it's a collective form or in the individual form. That is what we have discussed. Okay. And we know basically if any member misuses the privileges, okay, and if there is any proven case in which the parliamentary member used the privilege in a manner which is not authenticated, which is not validated as per the rules or procedures of the houses. So that will be considered as a breach. Okay. After this, the another concept that we have seen, that was the contempt of the house. So if we start with this, so we can say when any individual or any authority disregards or attacks any of the privileges, rights and immunities either of the member individually or of the house in its collective capacity, then this is known as the breach of privilege and it is punishable by the house. Okay, like we can say there are various privileges, rights and immunities that are provided to the individuals and authority for a certain way. Okay, so that they could feel free while expressing their concerns, while you can say performing their official duties, and while protecting the democracy, then they could use it. But these rights, privileges and immunities are designed in a certain way that they should be used for some authenticated purpose. If they use in a form that this is disregards and attacks any of the privileges, rights and immunities, okay, either of the member individually or in the house in the collective capacity, so that is unauthenticated way, and that is collectively termed as the breach of privilege. Okay, and as a breach there is a punishable prescription by the house. Got it? Thereafter what we say, any act or omission which obstructs a house of parliament, its member or its officers in performance of their functions, which has a tendency directly or indirectly to produce results against the dignity, authority and honor of the house, is treated as a contempt of the house. Okay, so here we had seen the two terms, breach of privilege and the contempt of the house, and here we had seen the definitions of them, and you can say here we have seen their meaning. Breach of privilege means when any individual authority disregards or attacks any of the privileges, rights and immunities either of the house individually or of the house in the collective capacity. This is termed as the breach of privilege and punishable by the house. This is the breach of privilege. While we talk about the contempt of the house, so is there any act or omission that is of the nature to obstruct a house of parliament or its member or officer in performance of their functions or which having a tendency? It means that this act either obstructing them to perform their functions or the act or omission having the tendency, whether in the direct form or indirect form, to produce results against the dignity, authority and the honor of the house. So this is known as the contempt of the house. So there are two ways in the contempt of the house. Either obstructs the duties of the officials, members and the house. Second, directly or indirectly producing the results which harms the dignity, authority and honor of the house. Okay. So these are the two areas. So the two phrases, the breach of privilege and the contempt of the house, are used interchangeably. They have the different implications. Okay. So you can say, however, here also we had learned them together. Breach of privilege, contempt of the house, we have seen them together, but they could be used interchangeably, but they are having the different implication. Okay. So their use are alternatively, but their implications are not. They are different. Okay. So basically when we talk about a breach of privilege, so basically normally a breach of privilege may amount to the contempt of the house. Okay. Likewise, contempt of the house may include a breach of privilege also. So we can say the contempt of the house is broader in comparison with the breach of privilege. Okay. They both having the different thing. They both having the different meanings. Got it? Contempt of the house, however, has wider implications. Okay. Contempt of the house, however, has wider implications. While there may be a contempt of the house without specifically committing a breach of privilege. It means that breach of privilege is some kind of part of the contempt of the house, but it is not covers the contempt of the house, but contempt of the house covers the breach of privilege. So there could be contempt of the house without specifically committing a breach of privilege. Got it? Similarly, actions which are not breaches of any specific privilege, but are offenses against the dignity and authority of the house amount to the contempt of the house. It means that here the member and authority did something which could not be considered as a breach to any privilege, but the action which they had committed directly or indirectly having a tendency which is committing the offenses against the dignity and authority of the house, that would be regarded as a contempt of the house. Got it? So, for example, disobedience to a legitimate order of the house is not a breach of privilege, but can be punished as contempt of the house. Okay? Disobedience means, suppose the member on authority did something in a manner that they disobeyed the instructions by the presiding officer, or even legitimate order means the rules prescribed in the parliamentary proceedings. They disobeyed them. Okay, due to some reason, and you can say due to the heat of the moment, they did this kind of things. So that will be not a breach of privilege. Okay, it will not considered under the breach of privilege, but because this is the disobedience to the legitimate order and the legitimate order of the house, so that could be considered under the contempt of the house. Okay, remember this thing. Alright. For example, disobedience to legitimate order of the house is not a breach of privilege, but can be punished as contempt of the house. Got it? So here, please keep the difference in your mind about the contempt of the house and the breach of privilege, because in the examinations, the question could be asked, Okay, and if you are not very much clear in the concepts, then what will happen? You will get confused, and there is high tendency that you will mark the wrong answer. And we know the wrong answer will take your marks. Got it? Here, now we have the sources of privileges. Okay, we know there are the privileges to the parliament, and we know if anything has been provided to anyone, so there must be some source from where it's deriving its power. So here, if we're talking about the privileges, then it's become very much important. Then we must be aware about the sources of privileges. Okay, like what are the sources which empowers these privileges about which we are talking right now. Okay, so here, if we start tracking it down, so originally the constitution, there is an article 105. Remember, the articles are very important to remember. Okay, because the question could be asked in a repeated way. Like, the question could be asked in two ways. The first way is that the question like be this: article 105 provides for which? Sources of powers to the governor, sources of privileges to the parliamentary members, presidential elections, vice president elections. This is the first type, and we know the answer should be sources of privileges. Again, the question could be changed. Sources of privileges are guaranteed by, and you can say are empowered by which articles? Options are Article 112, Article 110, Article 105, Article 368. So, if we, you can say, have cleared the concept in the mind very much, then we will mark the correct answer. That will be an Article 105. Got it? So, the Constitution Article 105 expressly mentioned two privileges. And what are these? First is the freedom of speech in parliament. And right of publication of its proceedings. Got it? It means that doesn't matter any member. For let me tell you example. If we try to portray it as a picture, so let us take a picture. All right. So here you can see, and you can say here you can connect it with yourself. Suppose you are in the classroom right now. All right. In classroom there are 100 students. Okay. And then what happened? That out of 100, the 70 students have made a group X. Okay. And then remaining 30 students are in the group Y. Okay. Even the group Y having the division in which the 25 students are from group Y and the 5 students are from group Z. So if you take it into the consideration, then what you will think? Any matter that we'll discuss in the classroom. So if any voting, any speech organizes on it. So could you imagine that the group Z members, that are the only 5 members, they could have a same power, same impact, same speaking rights as per the group X and Y? No, because the group X having the 70 members, they will have the majority, they will have the maximum power. All right. And group Y having the 25 members, so they will be in the second position. So what will happen? They both will try to suppress the group Z and will try to, you can say, push them down. This is normally happens. Okay. If we connect it to the parliament, in parliament we know there is a, you can say there is a always majority party rule. Got it? We know there is a majority party rule in parliament. Okay. So if we take it this way, so we can say here there is a one party, party X, second party, party Y, third party, party Z. Party X having the 70% of seats, party Y having the 25% of seats, and party Z having the 5% of seats. So if you take it through this way, what you will think? Is there any chances that the party Z will have the same implication, same power, and same freedom of speech as comparison with the party X and Y? No. Clear? No. Okay. That's why it's become highly important that the freedom of speech in the parliament must be available for all. Okay. So that doesn't matter whether the member belongs to the party which having a lesser seats, which having a less seat, which having the more seats. Okay. The person must have the freedom of speech in the equal manner. Okay. First thing is that. Second, the right of publication of its proceedings. What does it mean? So basically, we know whatsoever proceedings happens in the parliament, it is the right the outside members like me and you should be aware about it. So no restrictions could be put on the proceedings of the parliament, okay, until or unless there is a secret sitting. Because the secret sitting, the emergency meetings, the confidential meetings, their proceedings could not be published due to some various reasons of the national security issues. Got it? With this regard to the other privileges, it provided that they were to be the same as those of the British House of Commons. British House of Commons is the lower house. Its committees and its members on the date of its commencement, therefore 26 January 1950 until defined by the Parliament. Okay, so we can say basically first these two provisions are provided by the Article 105, freedom of speech, and the right to publish the proceedings of the House. These two articles are constitutionally provided. These two privileges basically. Here, if we talk about the other privileges, so the other privileges are from the same way as from the British House of Commons, that is a lower house in the British Parliament. So whatsoever the rights and the privileges given to the members of the British House of Commons and the committees members of the British House of Commons, these same were given to the parliamentary members of India on the commencement of the Constitution on 26 January 1950. And this provision is provided until it was defined by the Parliament. Got it? After this, the 44th Amendment Act of 1978 provided that the other privileges of each House of Parliament, its committees and its members are to be those which had on the date of its commencement 20 June 1979 until defined by the Parliament. So you can say other privileges. We are talking about other privileges. We are not talking about these two privileges, freedom of speech and the right of publication of its proceedings, because these are powered by 105. If we talk about the other privileges, so basically first they provided as per the pattern of British House of Commons, its committees and the members of its committees. Okay, from the commencement of 26 January 1950, the commencement of the Constitution, and the power given to the Parliament, if they want to define them, they could define them. After this, what happened? That was the year of 1978 when the 44th Amendment Act came into the picture. Okay, and this act provided that the other privileges of each house of the Parliament, their committees and members, are which they had on the date of its commitment. It means that again the other privileges provided them on 20 June 1979 when the 44th Amendment Act of 1978 commenced. Okay, and again the power given to the Parliament, that it is on the Parliament until they define that what rights and privileges would be there and what not. This means that the position with regard to the other privileges remains same. Okay, there is no you can say so big change in it. Okay, the things are very much similar. In other words, amendment has made only verbal changes by dropping a direct reference to the British House of Commons without making any change in the implication of the provision. So verbal changes, what do you mean by the verbal changes? Verbal changes means that their words and their definitions are changed, but the basic principles, the basic implication of the provisions are still the same as per the pattern of British House of Commons, whether it's 26 January 1950 when the Constitution commenced, whether it's 29 June or 20 June 1979 when the 44th Amendment Act of 1978 commenced. Okay, the things remain same. After this, you can say it should be noted here that the Parliament till now has not made any special law to exhaustively codify all the privileges. Okay, so that's why they are based on the 5 sources mainly, like constitutional privileges, okay, various laws made by the Parliament over the period of time, rules of both the houses, all right, parliamentary conventions and the judicial interpretations. So these are the 5 sources, okay, that codified all the privileges. Okay, remember them. The doctrine of sovereignty of Parliament is associated with the British Parliament. So here we are going to talk about the new topic, that is the sovereignty of the Parliament. we are going to start it, and this is the last topic. So if we talk about the sovereignty of parliament, so basically it is associated with the British Parliament. Like you can say in the starting of these lectures, and you can say in the series of parliament, we had discussed several facts and figures. Like if we talk about the Constitution of India, all right, if we talk about the Constitution of India, so we know the Indian Constitution is mainly inspired by the two constitutions of the world, the British and the American. Mainly provisions we had borrowed from them, mainly things we had borrowed from them. All right, but there is a difference in their constitution, and what is that? If we talk about the British model is unwritten constitution. Okay, so that's why whatsoever the rules the parliament will decide, that rules will be implemented. So here the parliament having the supremacy. Okay, if we talk about the American Constitution, this is the written constitution. Rules, regulations, procedures, definitions and all are clearly well defined. In these cases, basically you can say the American Constitution have the supremacy over the American Parliament. Okay, so if we talk about the sovereignty of the Parliament, it means that if we talk about the power of the Parliament, then basically that is associated with the British Parliament. Why? Because the Britishers having the unwritten constitution, that's why their Parliament having the supremacy over the constitutional provisions. Okay, so remember the doctrine of sovereignty of Parliament is associated with British Parliament. The reason I have told you. Sovereignty means the supreme power within the state. No other authority is upper than the authority, and no other authority could contain and you can say continue and control the other authority. Okay, that supreme power in the Great Britain lies with the Parliament. Why? Because there is unwritten constitution, so that's why the Parliament is the one which defines the provisions in the you can say constitutional manners. There are no legal restrictions on their authority and jurisdiction because no legal restrictions have been written down and defined clearly anywhere. Got it? Therefore, the sovereignty of Parliament, the parliamentary supremacy is a cardinal feature of the British constitutional system. Cardinal feature means the essential feature and the most important feature of the British constitutional system. That means the Parliament of the British having the supreme power in defining the meanings of the constitution. And there is a person, A.V. Dicey, who is the British jurist, and this principle has three implications. Okay, first implication is that Parliament can make, amend, substitute or repeal any law. Do you follow me? A British political analyst said the British Parliament can do everything except make a woman a man and a man a woman. Okay, it means that they could not change the basic principles. Okay, they could not change the basic principles, but they could change most of the implications of them. All right, because they having no legal restrictions, because the things are not defined, the things are not written, so there is no way to put the you can say restriction and stop on the powers of the Parliament. The Parliament can make constitutional laws by the same procedure as the ordinary laws. Okay, in other words, there is no legal distinction between the constituent authority and the legislative authority. And we know in India there is a clearly well-defined authority. The Indian Parliament could not exercise their power in whichever way. Okay, after this we can say the parliamentary laws cannot be declared invalid by the judiciary as being unconstitutional. Why? Because there is no system of judicial review in Britain. If we talk about India and if we talk about USA, how does the judicial system works? They have the constitution, everything is written down here. Then what they do, they just take the bill and the legislation, and you can say the course of action exercised by the legislature. Then they will match it with the written provisions of the constitution, and then they interpret whether the thing is constitutional or not. This is the process. But if we take it in the Indian way, sorry, in the Britain way, in Britain there is no written constitution. Then how could the judiciary will take the written copy of the constitution, the principles and all? So that's why the judicial review is not effectively working in the Britain. There is no provision of it even. Got it? So if we talk about the sovereignty of the parliament, so first is written nature of the constitution. The constitution is the fundamental law of the land in our country, we know. Define the authority and jurisdiction of three organs of the union government and the nature of interrelationship between them. Three organs: legislature, executive and judiciary. Hence, the parliament has to operate within the limits prescribed by the constitution. Why? Because it's clearly defined the authority and the jurisdiction of all the organs. Not like the Britain, where the things are not defined and basically that are already, you can say, depends upon the discretionary of the parliament. There is also a legal distinction between the legislative authority and the constitutional authority of the parliament. Moreover, to effect certain amendments to the constitution, the rectification of half of the states is also required so that the arbitrary nature of the parliament's powers could be held. In Britain, on the other hand, the constitution is neither written nor there is anything like a fundamental law of the land, and entire thing is totally dependent upon the parliamentary discretion. Got it? After this, if we talk about second is the federal system of the government. India has the federal system of government with a constitutional division of powers between the union and the state, union-list, state-list and all. Both have to operate within the spheres allotted to them. Hence, the law-making authority of the parliaments get confined to the subject which are enumerated in the union list and the concurrent list. And this could not be extend to the subjects which are enumerated in the state list except the 5 abnormal circumstances, and that are also for a short period, not for everlasting period. 5 circumstances we had already discussed. On Britain, on the other hand, has a unity system of government. All the powers are vested in the center. There is no provision of the division of powers. System of judicial review existing in India. The adoption of an independent judiciary with the power of judicial review also restrict the supremacy of our parliament. Their actions could be judged. Both the Supreme Court and High Courts can declare the laws enacted by the parliament as void and ultra vires, means the unconstitutional, if they contravene any provision of the constitution. Why everything is written down? They just compare it with the course of actions and then interpret and find out the unconstitutional phases. On the other hand, there is no system of judicial review in Britain. The British courts have to apply the parliamentary laws to the specific cases without examining their constitutionality, legality or reasonableness. Got it? After this, the fundamental rights. The authority of the parliament also restricted by the incorporation of a code of justiciable fundamental rights under the part 3 of the constitution. Article 13 prohibits the states from making a law that either takes away totally or abrogates in part a fundamental right. Hence, the parliamentary law that contravenes the fundamental rights shall be void. Britain, on the other hand, there is no codification of justiciable fundamental rights in the constitution. The British Parliament also not made any law that lays down the fundamental rights of the citizens. Got it? However, it does not mean that the British citizens do not have a right. Though there is no charter guaranteeing the rights, there is maximum liberty in the Britain due to the existence of rule of law. Therefore, even though the nomenclature and the organizational pattern of a parliament is similar to that of the British Parliament, there is substantial difference between the two. The Indian Parliament is not a sovereign body in the sense which the British Parliament is a sovereign body. Unlike the British Parliament, the authority and jurisdiction of the Indian Parliament are defined, limited and restrained by the Constitution that is not applicable to the British Parliament. Got it? In this regard, the Indian Parliament is similar to the American legislature, which is known as the Congress. In USA also, the sovereignty of Congress is legally restricted by the written character of the Constitution, federal system of government, the system of judicial review, and the Bill of Rights. Got it? Here we have some, you can say, allocation of seats. All right. So here just is, you can say, the change, the data could be changed. All right. Just is for your information part. It is not so important from the examination point of view. Andhra Pradesh 11 seats in Rajya Sabha, 25 in Lok Sabha. Arunachal 1 seat in Rajya Sabha, 2 in the Lok Sabha. Assam 7 in Rajya Sabha, 14 in the Lok Sabha. Bihar 16 in Rajya Sabha, 14 in Lok Sabha. Chhattisgarh 5 in Rajya Sabha and 11 in Lok Sabha. Goa 1 in Rajya Sabha, 22 in Lok Sabha. Gujarat 11 in Rajya Sabha, 26 in Lok Sabha. Haryana 5 in Rajya Sabha, 10 in Lok Sabha. Himachal Pradesh 3 in Rajya Sabha, 4 in Lok Sabha. Jharkhand 6 in Rajya Sabha, 14 in Lok Sabha. Karnataka 12 in Rajya Sabha, 28 in Lok Sabha. Kerala 9 in Rajya Sabha, 20 in Lok Sabha. Madhya Pradesh 11 in Rajya Sabha and 29 in Lok Sabha. Maharashtra 19 in Rajya Sabha, 48 in Lok Sabha. Manipur 1 in Rajya Sabha, 2 in Lok Sabha. Meghalaya 1 in Rajya Sabha, 2 in Lok Sabha. Mizoram 1 in Rajya Sabha, 1 in Lok Sabha. Nagaland 1 in Rajya Sabha, 1 in Lok Sabha. Odisha 10 in Rajya Sabha and 21 in Lok Sabha. Punjab 7 in Rajya Sabha, 13 in Lok Sabha. Rajasthan 10 in Rajya Sabha, 25 in Lok Sabha. Sikkim 1 in Rajya Sabha and 1 in Lok Sabha. Tamil Nadu 18 in Rajya Sabha, 39 in Lok Sabha. Telangana 7 in Rajya Sabha, 17 in Lok Sabha. Tripura 1 in Rajya Sabha, 2 in Lok Sabha. Uttarakhand 3 in Rajya Sabha, 5 in Lok Sabha. Uttar Pradesh 31 in Rajya Sabha and 18 Lok Sabha. West Bengal 10 in Rajya Sabha and 42 in Lok Sabha. Got it? So students, basically in this lecture we have done with the parliament. In the next lecture we will start with another important topic. Till then, just revise the facts and figures that all we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture, and what we say thank you.